increased rate of mobility amongst associates, a much increased rate of dissatisfaction amongst associates with their professional lifestyle, particularly as the size of the firms in which they work increases, increasing demands amongst associates for higher compensation and an increasingly aggressive negotiation by associates for higher compensation, increased demands by associates for earlier admission to partnership at a time when the firm's partners tend to be looking to spread out that period, and an increasing demand amongst associates for the early delivery of high-quality, high-responsibility work. Many of those trends exist in Canada. I think they're going to continue to exist in Canada. I think they're going to be felt more intensely in Canada. Canadian law firms, Ontario law firms in particular, have been in the position for the last few years where the number of students coming out of the bar admission course, coming into practice, is very high. We can be very selective about the articling students that we hire. And I think that's true whatever kind of firm we're talking about, whether it's a large, middle, small-sized firm. There are students who are targeting all of those firms, all of those areas of practice, and they're beating down our doors. So look at our firm. We got in excess of 450 applications for articling positions last year and conducted almost 200 interviews before hiring 14 students. I don't think that experience is unusual amongst the larger firms, and I don't think that those percentages are unusual with any of us. We've got a tremendous opportunity to hire good students from a very attractive market. Students are, by and large, extremely well trained in the areas in which the law schools train them. And they're the best possible source of new associates, because no other system permits us the opportunity of such a long evaluation of that individual's ability. You get a CV in the mail from somebody who's in the bar admission course looking for a position. You can meet with him or her for an hour or 2 hours or 3 hours or 3 days. There's no way you're going to get as good a handle on that individual's ability as you will by having him or her work in your firm for a year and work with you. What we don't do sometimes is we don't commit the resources at the front end to that hiring process. We don't spend the time in getting the best students, and by the best students I don't necessarily mean those with the highest academic qualifications. Obviously, it's nice to have the gold medalists, but there are lots of students out there who aren't gold medalists, who are very capable and competent students who may be better suited to a particular firm's practice than the gold medalist. If the gold medalist is bound and determined that he or she wants to do aviation litigation, and if your firm doesn't practice in aviation litigation, I suggest to you there's not a lot of point in hiring the gold medalist for the sake of having the gold medalist in your law firm, because he or she is not going to be happy and you're not going to be happy. So you've got to hire, I think, with a view to the student's qualifications and also with a view to your needs. Where can we see this individual fitting into the firm's practice down the line? I come back again to future planning. Where is this firm going to be expanding in the future? What areas of that expansion are we going to need to recruit in, and what areas of that expansion are we going to need to recruit from students? The investment of time in the student hiring process, I suggest you can return very high dividends, and I commend the investment of that time to you most seriously. The other thing that we don't often do well once we get either students or associates in the door is we don't train them. We put them in a room, we give them a desk, we give them a telephone, we give them a briefcase. Some firms we may give them a map of the city. And we say, okay, off you go to work now. Please, keep dockets, be nice to the clients, don't offend anybody, don't get drunk at the firm parties, and work hard and you'll be a successful lawyer. It's not that simple, and we all know it's not that simple if we take the time to reflect back to when we were students and when we were young associates. You have to put in place a system which enables those associates to take the academic skills that they've learned at law school and translate them into practice. The client phones up and wants a quick opinion on question A and happens to get a student or a young associate. He doesn't want to start with Blackstone's commentaries and the development of the law since then. He wants an answer. That in itself can be a problem, because in law school, the professor looks down and says, here's the question, what's the answer? The student's supposed to have an answer. One of the hardest things, I think, for young lawyers and students to learn is that they don't always have to have the answer right away, and that there's nothing wrong in the right situation with saying to the client, I haven't got the faintest idea what the answer is to that question. Those are the kinds of practical skills, the kinds of levels of comfort that we've got to bring our students and associates to have. And they're only going to acquire those if they get an opportunity to work with the lawyers in the firm who have those skills. If they have a feeling that the doors are open to them to come and ask questions, to come and talk about problems, if the doors are open to them to come and acquire those skills that are already resident in the firm, they're going to develop, and they're going to develop successfully. They're not going to do you any good if you simply put a mailbox on the door and shove the work in through the mailbox and at the end of the year wait to see whether it comes out the bottom of the door or not. They're a resource, and you have to commit the time and the energy to develop that resource. And it's tough because we're all busy. We all have real work to do. We all have real clients out there to look after. And to mentally commit that unbillable time to sit down with your students and your associates and help them learn is a tough thing to do. In the larger firms, you need a committee, and you need, in my experience, you need a very aggressive committee that in effect goes around and beats heads to get people to spend the time with students and with associates to bring them along. Because if you don't do it, you'll lose the good ones, and you'll end up with the bad ones. And if you don't do it, you're cheating yourselves, because you're not getting the maximum potential out of those associates, the maximum resource that those associates can be to you. I suggest to you in the paper, and it's worth remembering, if you're in a firm that's in a growth pattern, and if you're looking at the kinds of things that Barry has talked about, capital interests on withdrawal, there's only one place that's going to be funded from, and that's from the associates that you hire today who are going to be your partners tomorrow when the time comes for you to retire and take that money out. But they're not bringing it in. The most sophisticated formula in the world ain't going to pay it out when you leave. If you spend the time with them, if you develop the programs, and if you commit the time to implement those programs for training, I suggest that problems of associate mobility rates and associate dissatisfaction will be minimized, because most young lawyers are no different from any other lawyers. They want to do good work, they want to do interesting work, and they want to do it in an environment where they're happy and where they're comfortable with the people that they work with. If you can address those concerns, you'll get good associates, you'll develop them well, and you'll reap the benefits from them. The last thing I want to talk about very briefly before I let you have coffee is amalgamation with other firms. It's a subject about which I am uniquely qualified to speak because I have no experience in it whatsoever, and accordingly I can offer you a whole bunch of suggestions without any possibility of being in the position of knowing that I'm telling you something which is wrong. Bob Milnes in his paper and in mine both refer to the arriving era of the national law firm. I know Bob's paper because his was prepared and completed in a very timely fashion, which mine wasn't. But my paper as well were both written before the recent announcement of the proposed amalgamation between McCarthy's and the Vancouver law firm. The national law firm is upon us, And I'd be prepared to predict that in 4 or 5 years' time, we're going to have 6 or 7 of them in this country. Anyway, maybe more. We're going to have large national firms, we're going to have multi-city national firms, and there's going to be enormous pressure on all firms to deal with the amalgamation issue, because either you're going to be in the position where you're being pressured to target an amalgamation, or you're the target, and somebody's knocking on your door saying, how'd you like to be our London, Ontario portion of Smith & Brown? How would you like to be our Ottawa portion of Smith & Brown? How would you like to join with us because we're in Victoria and you're in Toronto? I've given you in the paper some suggestions of things that you might look at when you begin the process of addressing the question of amalgamation. Most of the things that I've given you are what I would call economic cost factors. How many extra typewriters are we going to have? How many extra Xerox machines or photocopy machines are we going to have? What are we going to do with our existing leases and so on? There are also social costs involved, and I can't evaluate them for you, but they're important. Again, to hark back to the U.S. experience, one of the things that large U.S. firms, particularly those that have gone to significant numbers of branch office operations and international office operations have discovered is that there are very, very high social costs connected with those decisions. People become unhappy, or can become unhappy. They're being asked to pick up their family and move from New York to San Francisco. Or all of a sudden, you've got a big lateral integration problem in the firm. You've got 4 new lawyers coming into their areas of practice, and 3 of them are senior, and 1 of them is junior, and they've got clients who cause conflict of interest problems with your clients. Some of the problems just relate to sheer size. There are still lots of lawyers around, and I think in many ways I'm probably one of them, who are scared of size. Size is frightening. Size produces a whole lot of problems which we're not good at dealing at. We don't understand some of those problems. The best future plan can't anticipate and address all of those problems. And I suggest to you that it's important to know how the lawyers in your firm feel about those problems before you merrily go off embarking on amalgamations and branch offices and expansion programs which are dramatic in size. If there is a strong internal desire amongst the lawyers to control size, to maintain it in a manageable, what is perceived to be a manageable fashion, then the social costs of a large amalgamation or even a small amalgamation may be devastating. Look at all of those things. Look at the philosophical side as well as the economic side. Look at some of the things that I suggest in my paper. I don't suggest for a moment that the list is exhaustive. But there are a few of the things that you have to be concerned with. And I guess as a parting suggestion, don't be rushed into it. We're all on a path which involves us in practicing law for a lot of years to come. We're going to have to practice it in a changing environment. It's going to be a tough environment to deal with, to understand, and to plan for. The last thing we need to do is charge into it blind. If you take nothing else away, please take away the message that a little thoughtful consideration of these topics before you leap into them is, in my view, an investment that's well worth the expenditure. Thank you very much.
Just before we break for coffee, we could have a short question period if anyone has any questions. There will be a question period at the end of the morning, so does anyone have any questions they wish to ask the first 2 speakers? Yeah.
I'd like to ask Mr. Osborne this question. I'm with you when you talk about needs, matching needs with clients and lawyers. I part try and associate that with a particular lawsuit, and you talk about the client's objectives. And I wonder if you subscribing to the fact that you have to do the better matching of needs, do you feel that you're going to have to institutionalize that claim for need in the law firm? And what I mean by that, you're suggesting that each lawyer in the firm bring back the client that you just win the lawsuit on. But will you have to go down the road of market research in order to institutionalize those needs of clients?
Chris, before answering, would you summarize the question for the videotape?
I'm not sure that I can summarize it fully, but let me try and do that, and you tell me how close I come. Your question, I think, is, am I inviting lawyers to embark on a path which involves long-range market research, long-range analysis of client needs, the development of formal structures for evaluating client needs, and I suppose moving the lawyer perhaps from being the professional into being something perhaps more akin to a psychologist lawyer. Is that a fair summary, or am I missing the thrust of it?
No, I think you're on the right track. I just wonder how you will get at the client's needs if you don't do that.
All right. I think my point that I was trying to make was that the easiest way to get at the client's needs is to talk to the client himself or herself about those needs. And it's something that, certainly in my experience, for a long time I didn't do, and I suspect that most lawyers don't do enough of and don't do it well. I don't think you have to be a trained psychologist or market research person to uncover some fairly basic aspirations that clients have. I try and address some of them in the paper. Clients, by and large, want the timely delivery of a legal service at a reasonable cost by a lawyer in whom they have confidence and who they feel has some interest in protecting their objectives. Now, their objectives may be unrealistic, and that's one of the things that I think you have to talk to clients about to get from them a sense of what their objectives are. Because it may be that you can identify very early on that the client, for whatever reason, simply misunderstands the result that you as lawyer can hope to produce for that client. That's obviously something that it's important, in my view, to identify very early on and to set the client straight and say, either that's not a lawyer's job, or that's not a job that I can do for you, or it's not something that can be achieved for you in this case. Some clients do have quite extraordinary expectations of what either their lawyers or the legal system can provide for them. And there's nothing worse than getting well down the road in doing what you think is your job to the best of your ability and finding out that it bears no relationship to what the client had in mind. I think what I'm striving to suggest to you is nothing more than a development of an increased sensitivity to how the client views your role. We are in the final analysis a service industry, and our success or failure depends in large measure upon the perceptions that the client leaves us with. It's not easy to do. I don't think we have to try and do it at a very sophisticated level, but I think we have to try and do more of it than we have done so far.
Okay, in view of the time, we'll entertain one more question, and if any of you have other questions, perhaps you could hold them until the end of the morning. Yes, sir.
I'm just wondering if the panel could touch on the question of liability. referred to indirectly. That is, if you have the potential one partners in a number of business deals or whatever, and that may have impact on the partnership assets if something should go wrong, or the question of a partner absconding with funds or whatever. How is that protected in the bigger firm situation, where you don't have the sort of hands-on control that you might in a smaller operation?
Sure. I think the question was, how do you effectively provide in a partnership agreement that any of the partners is not going to be exposing partnership assets to seizure? I think the easy answer is sure. You can provide in your agreement that none of the partners is going to go out on a frolic of his own and sign personal guarantees all over the place, exposing his desk and furniture and your desk and furniture from his creditors. I think the reality is, you get into the dynamics of people. I think it's one of, it's easy when you've got two partners and you both sit down over lunch and talk about what you're going to do, and everybody knows the kind of sort of outside activities that everybody's involved in. I think one of the problems of growth, and I think, we don't need to go too far, but to Hamilton, to see examples of law firms where one or two of the senior partners got involved in outside activities that led to the bankruptcy of whole law firms. And I think that the ultimate answer is, when you choose your partners, you have to know the character of the people, the kind of outside activities they're involved in, and notwithstanding what you might put in your agreement, I think it's incumbent that everybody knows the limitations and the realities of outside activities that everybody's involved in. It is a bigger problem with larger firms, no question about it. When you've got 50, 60 partners, to know what everybody is involved in on the outside world, hey, you're at risk.
Do you ever consider bonding or anything like that? Is that ever considered in partnership agreements?
That isn't going to protect it.
Insurance funding?
I think that the reality is there's no effective way. One of the imperfections of partnerships, and our reality on our inability to incorporate our law practices, is that unlimited liability. Every time each of us signs a mortgage on our house and runs the risk of default, or our partners do the same thing, each of us as that person's partner is running some risk as well. I think that's the reality, and you can take all the insurance and professional insurance, liability insurance, a whole different kettle of fish.
Just on that point, I'm not aware of insurance or bonding being used in those circumstances for cross liabilities of partners. I don't know if any other member of the panel is. I've never heard of it in a law partnership.
I don't think you can buy it.
I beg your pardon?
You can't buy it.
Okay, that's the answer. Can't buy it.
There is a method of partially take care of that. I've gone through it, dealing with banks only, and they will accept the exclusion of the liability relating to the law firm. If you say, I guarantee personally, except with any assets of the partnership, they will accept that. If you have a good bank.
Sorry, I have to repeat your comments for the videotape. I think the comment from the floor was that banks are willing to exclude partnership liabilities in terms of looking at individual partners, particular loan arrangements. Again, in my experience, it depends, I think, on the loan arrangements. If the partner is borrowing $10 million, I think the bank may look a lot more closely. Okay, in view of the time, perhaps we should adjourn now for coffee and reconvene in about 15 minutes. Thank you. Gentleman in the first row wants to go on record that the Hamilton lawyers referred to earlier, in fact, moved to Toronto before they were disbarred. It's duly noted on the videotape, sir.
Was that the escape to Toronto? There's some issues.
Our next speaker this morning will talk on the income tax aspects of partnerships, and again is eminently qualified to do so. Our next speaker is Mr. Peter McQuillan. Mr. McQuillan is a partner in Ernst & Winnie, and until recently was the national tax partner of that firm. He has also served on the Board of Governors, in fact still is on the Board of Governors of the Canadian Tax Foundation. Mr. McQuillan graduated from the University of Toronto summa cum laude in 1962 and has had a distinguished career in the tax field. He's a prolific writer. Many of his articles are referred to in the materials, but an important one, and one that I would recommend you have for your libraries, is his book on understanding the taxation of partnerships, which is, in my view, the leading work in that area in Canada. Peter?
Thank you very much, Bob. Before we turn to partnerships, I had just wanted to introduce to you the story of the two twins whose parents became a little concerned when, notwithstanding the fact that they were twins, they grew up with such different personalities. One of the two twins was an extreme optimist, and everything that he faced in life he viewed optimistically. On the other hand, his twin brother, faced with exactly the same set of circumstances, approached every opportunity, every new event with pessimism. The parents tolerated this for a reasonable period of time, and once frustrated, turned for professional assistance. And having received professional assistance, they were advised that they should undertake an experiment to see if they could break the children of their optimism and pessimism and bring together the personalities, together more closely the personalities of the two twins. They decided that they would go home and fill one room with every imaginable toy on earth that the young twin, who was a pessimist, could ever hope to play with. And they decided that they would fill another room in the house with manure and a shovel, manure piled right high in the room. Into that room they decided that they would put the optimistic twin. They left the two twins in the room for a period of about 1 hour, and at the end of the 1 hour the two parents went up to see how the twins were getting along. They opened the door to the room full of toys, looked in to find the pessimistic child again in tears, crying, not enjoying the toys, having unwrapped and played with only about half the toys in the room. They asked the pessimistic child why, surrounded by so many wonderful things, he could be so unhappy. He said that he was very disappointed that his brother wasn't with him to share those toys and to share the experience and the fun of playing with all those things. The parents accepted that, proceeded to the next room. They opened the door, and they found the optimistic child in the room with a shovel, lifting the manure and throwing it over his shoulder, lifting the manure and throwing it over its shoulder, with a big smile on his face and a grin, and obviously enjoying himself. And the parent said, "Son, how can you, in a room full of manure, have such a wonderful outlook and be so enjoying the shoveling of the manure?" And that optimistic child remarked, "In a room with so much manure, there must be a pony here somewhere." The same can be said of a survey of the tax considerations of partnerships. With so much manure, there must be a pony here somewhere. Let us set out and survey some of the tax considerations that surround the coming and going of partners and the taxation of partners. And I stress this really is a survey. You can see the paper is perhaps a little longer than I can reasonably cover this morning. So we'll see we'll touch some of the highlights, and I hope that it will be useful to you as perhaps a reference point or to stimulate some questions at the end of this session. We note that prior to 1972, the Income Tax Act had about a one-sentence reference to partnerships. When we moved into the new Income Tax Act in 1972, we had a whole subdivision of the Act devoted to the reckoning of income for partners and partnerships. And we're told that we're to compute the income of a partnership as if it were a separate person. So the whole reckoning of income, the recognizing of revenue, the recognizing of deduction is done first at the partnership level. In Canada, there is no partnership return that formally has to be filed with an income tax return. That income or loss is then allocated out to the partners, and the partners themselves will recognize on their own personal return the net income or net loss of that partnership for the year. So the first element of tax planning that we note on the bottom of the first page of the material that you have is that the partners will have the opportunity to select the appropriate year-end for the partnership. If you anticipate that the first 3 or 4 months of the partnership will not be profitable, you might call a quick year-end to enjoy the loss for that short fiscal period. If you feel the partnership is implicitly profitable through each and every month, then you will want to defer the recognition of the partnership income, rolling it forward to the next calendar year, and hence we have so many January, February, and March professional partnerships. Frequently, the partnership agreement will have formulas for the allocation of cash among the partners. The formula may pay out a salary, and it may be called a salary in the agreement, or it may merely be called a draw. In turn, the partnership agreement may call for a distribution of cash as interest on the capital account of the partners. Notwithstanding that kind of language, either in practice or right in the agreement, this thing called salary, this thing called draw, and even interest on a capital account is not interest and it's not salary. It is just a manner of reckoning the business income or the business loss of the professional partnership, and is only recognized at the end of the fiscal period of the partnership, and as I say, is recognized as professional income, not as interest. In turn, if a partner makes a loan to a partnership and enjoys interest from the partnership, now let us for a minute distinguish interest being paid by the partnership on the partner's capital account. Let us distinguish that from interest being paid on a loan to the partnership by the partner as a loan. That interest is interest and is reckoned as property income, but the interest will not allow the receiving partner to claim the $1,000 exclusion of Canadian source interest. I would invite you in those circumstances to consider rearranging your affairs and perhaps have your spouse lend money to the partnership rather than the partner, and the spouse will not be a member of the partnership. The spouse will be entitled to the $1,000 exclusion. Furthermore, in a number of professional partnerships, our own included, it's felt that for those partners, and I'm not one of them, who has surplus cash in the family, the rate of return that can be earned by the family members by lending to the partnership is greater than the rate of return that they're going to earn on CDs, term deposits, and so on. As I say, surplus cash has not been among my many problems. Frequently, business expenses will be incurred outside of the partnership, and so frequently the partners ask, can I deduct expenses that are incurred outside of the partnership that are not reimbursed by the partnership? We've had the pleasure of being one of the few national public accounting firms ever to be audited by Revenue Canada, and this was an area of special attention, and Revenue Canada started from the posture that if an expense had been incurred by a partner personally and was unreimbursed by the partnership, there was a presumption that that was not an expense that the partnership per se regarded as having been incurred on its behalf. Now, obviously, a long process of higgle and biggle followed, but you are battling a presumption, an unfavorable presumption that is not a business expense if your partners don't feel that it is reimbursable. Now, obviously, to the extent that everyone has a $4,000 non-accountable business development item that he takes outside of the partnership, if every partner is doing it in some pro rata amount, it follows that that is almost the same as if it were done within the partnership. If you borrow money to buy a partnership interest, and I'm going to be talking about the acquisition of partnership interest in a minute, but if you borrow money to buy a partnership interest, clearly the interest incurred on those monies borrowed are deductible. They have been laid out to earn income. But the hook, and I call your attention to this because I suggest to you that 26.6% of the people in the room today are offside on this point. If your partnership has borrowed money, and if you have overdrawn your capital account on an intra-year basis, there is a very strong argument that your partnership has borrowed monies not to earn business income within the partnership, but has borrowed money to pay out to a partner for his personal use and enjoyment. Now, there is a risk on audit that Revenue Canada will look very carefully at deficit capital accounts, particularly if your year-end capital account is also a deficit capital account. And bear in mind, you may undergo special scrutiny as to the deductibility within the partnership of that particular interest expense. Reference was made earlier to the fact that since 1971, professional practices are on what is called the modified accrual basis, and that is that there's a full recognition as income for accounts that are billed or billable, but there's no need to value work in progress. Two comments there. To the extent that you're in a professional practice, and if you are in the habit of receiving retainers, or if you are paid in advance for services that have not yet been rendered, notwithstanding the fact that you're required to recognize those retainers or to recognize those prepaid fees as income, you must recognize them as income, but you may claim an offsetting reserve in reasonable amount with respect to services that are to be rendered after the fiscal period of the partnership. In turn, to the extent that you have incurred on behalf of a client reimbursable costs that have not yet been billed to your client, it is not uncommon for your accountant to take those unreimbursed expenses that have not yet been passed on to your client at year end, to take those and inventory them as part of the work in process of the firm. Notwithstanding that it is good accounting to inventory those and show them as an asset on the balance sheet of the law practice, it is quite appropriate to deduct those for tax purposes on an as-incurred basis. So for tax purposes, you would not have an inventory, a closing inventory of unreimbursed expenses. They would be deducted on an as-you-go basis. In terms of entering the professional practice, in terms of entering the partnership, we start off, first of all, with the question, if a partner comes into a law firm, does that partnership dissolve? Is there a termination of the old partnership and the creation of a new partnership? And obviously, this is a point of law. And in the absence, well, let us assume then that this issue is best addressed by having a continuity clause in the partnership agreement, a clause that says that partners may come and partners may go, and the partnership itself will not be dissolved each time a partner comes and goes. If we have that particular situation, just a word on the partner coming out of his partnership in order to come into your partnership. As the partner comes out of his old partnership, he should first of all be interested in what is his share of the income for the stub period. Now, if the agreements say that it will be computed in accordance with generally accepted accounting principles, and that is his income for the stub period, it's important to recognize that while generally accepted accounting principles may permit the computation of a stub period income to that departing partner, it's important to recognize that generally accepted accounting principles do not necessarily yield the same quantum of income as would be arrived at for tax purposes. The quantum could be reasonably more or reasonably less for tax purposes. So if an agreement talks to stub period earnings being computed with reference to generally accepted accounting principles, make sure that it goes on and talks to tax treatment as well, and I'm going to come back to that point in a few minutes. In turn, if a partner is withdrawing from a professional practice, to the extent that he takes anything from the practice, he has two events, two tax considerations. One consideration is he has a cost base in the partnership that he is leaving. Will he receive from that partnership amounts that will trigger a capital gain because he has received proceeds from the partnership greater than his adjusted cost base in the partnership? More importantly, and more contentious an issue, is the fact that when a partner leaves a partnership and takes assets with him, such as goodwill, work in progress, his own furniture and fixtures, there is a deemed disposition to the partnership from which he is leaving, a deemed disposition of those assets at their full fair market value. So now we have the partnership having passed out goodwill, having passed out work in progress, having passed out the antique desk and 3 or 4 beautiful paintings to the departing partner, and that old partnership is deemed to have disposed of all of those assets at full fair market value. Now, presumably, to the extent that the partner is taking them with him, that is clearly his claim against the partnership. But even though that may be his entitlement in terms of physical possession, who should pay the tax on all that deemed income and deemed disposition? Equitably, probably, it should be the departing partner. Now, that's easily addressed with certain assets. It's most easily addressed with work in process. The work in process, let us assume that it's on the books of the law partnership for nil and it has a fair market value of $100,000. The partner withdraws from the old partnership. The old partnership has a deemed disposition of that work in process for $100,000, has $100,000 of income that for tax purposes should be allocated to the departing partner. Now the departing partner stands holding his work in process, a deemed allocation of $100,000 of taxable income. Unless that departing partner does something before he enters his new law partnership, he has an immediate tax problem. He has $100,000 of income on his work in process and he hasn't realized his work in process. That partner, having received his own work in process, must immediately elect, under the Income Tax Act, to have that work in process in his own hands, elected back down to zero. That will give him a tax deduction of $100,000 that offsets the $100,000 of income allocated to him from the partnership when he left. In turn, when he enters your law firm and he conveys into your law firm that work in process, he and your law partnership will have to file an election in which it is recognized that he is bringing into the law firm work in process that may have a value for accounting purposes of $100,000, but that for tax purposes now has a basis of nil. When he conveys that work in process into your law firm, he may have a capital account showing $100,000 of capital, but the law firm has no basis in the assets. And again, you will want your agreement to say, should he ever withdraw that capital from your firm, you will have the right to allocate $100,000 of taxable income to him when he leaves the law firm. Now, this whole area of coming and going, there are a number of leading cases on this particular subject. And surprisingly, and I thought they had chosen my co-speakers at random, but I think they chose them to illustrate the leading cases. But 2 of the people who share the front of the room with me are friends or colleagues of people who have been involved in tax cases regarding the nature of amounts received from a partnership when you withdraw from the partnership. Now, the agreement, your partnership agreement, should be very explicit, first as to the commercial result that the law firm wants to achieve when a partner departs, and equally specific, it should deal with the tax treatment to be accorded. Now, Revenue Canada do not enjoy litigating the partnership area. There are very few reported cases on any aspects of partnership. Revenue Canada are prepared, this is perhaps a mild overstatement, but in my experience, Revenue Canada are prepared to accept any treatment so long as the departing partner and the law firm from which he has departed will treat the payment consistently. So long as both parties are consistent in their treatment, Revenue Canada will ordinarily not intervene and recharacterize a payment. So if both parties want the payment to be ordinary income and ordinary deduction, that's fine to Revenue Canada. If both parties want the payment to be a capital payment, that too is fine to Revenue Canada. Consistency is the key. If you read the partnership agreements, you will frequently find that the partnership agreement will speak to the amount of money to be paid to this departing partner and will say that it's to be reckoned by looking at his billings in a preceding period, or looking at his share of work in process, or his share of goodwill as notionally determined. It can have any particular formula you want to have in the agreement. It can speak to things that look like ordinary income, such as work in process, and notwithstanding the fact that it may have been computed with reference to something that gives rise to ordinary income, Revenue Canada will still take it as capital if both parties will file as capital. Within the past year, I've met with 2 clients who had left law firms, and when they left the law firm, their capital account was in a deficit balance. The agreement that they arrived at with their old partnership was that the old partnership would forgive, and that was the language used in the agreements, would forgive their deficient capital account. Both of those departing partners arrived in my office believing that they had negotiated a capital settlement with their former partners. To them, the forgiveness of a capital account smacked of capital, sounded like a capital transaction, and therefore logically should have been capital. Logically, perhaps it should have been a capital treatment, but notwithstanding the logic, by the time the auditors for that law firm had prepared the accounts for the law firm at the end of the year in which he had withdrawn, that law firm had allocated taxable income out to the partner who had departed, and they'd allocated taxable income out to him equal to his deficit capital account, and that was their interpretation of how they would backfill the forgiveness of a deficit capital account. And as I say, there are 2 cases. One of those cases states that, and I don't think that this is necessarily the best interpretation of the section, but right now, the leading case says that the surviving partners may enter into an agreement, and that agreement will govern the character of the payment. Now, the section talks about an agreement among the partners, and as I say, this particular case says that you read those words to mean an agreement among the partners who remained after the partner had left. Now, as I say, I don't think that's necessarily the best interpretation of the section, but right now that is the interpretation and seems to give the remaining partners unilateral discretion in allocation. Therefore, the departing partner must protect himself by making sure that his agreement of departure talks to the tax treatment. What's my time?
7 minutes.
Another 7 minutes? Okay. Acquiring the interest in the partnership, we've dealt with the departing partner. Just a few comments on buying in. Barry earlier talked about several approaches that he has seen taken to buying in. I think it's important to recognize that a new prospective partner can come along and pay an amount into the partnership and have an interest in the partnership, and that will be a non-taxable event. There will be no deduction or tax adjustment enjoyed by the partnership, and the partner who puts his money in will have cost base in his partnership interest. In turn, if the prospective partner wants to buy into the law firm by buying out or buying a percentage interest from existing partners, the existing partners will have to look at their own cost base and make sure that they have maximized their cost base before they sell. Since income is not allocated during a year, but allocated to a partner only at the end of a year, Partners who are going to sell a partnership interest to another partner must be very careful to ensure that the transaction takes place immediately after the year end of the law firm. Because if it takes place at any time during the year of the law firm, the partner will reduce his cost base by his drawings during that year, but will not backfill his cost base by his share of the income that is accruing during that year. It's only at the end of the year that all that accruing income will come in and be enjoyed in the cost base of the old partner who is selling. So the perfect timing is immediately after the year end of the law firm. In turn, if you want a tax-free event, as between the buyer and the seller, it is still quite proper for the buyer to put his monies into the partnership by way of cost base, and once the monies are in the partnership, they may be drawn down as drawings by the other partners. And even if the other partners take their capital account into a deficit balance, the Income Tax Act tolerates a negative adjusted cost base in a partnership interest and does not deem a disposition. Now, this is a sensitive area. It's an area of tremendous abuse in the whole area of partnerships and their taxation, and it's not an area that people can rely on indefinitely. Perhaps someday, soon, Revenue Canada will say that you can no longer have a negative adjusted cost base in a partnership interest. In fact, it may be as early as next March or April that we have that particular change. In terms of merging professional partnerships, just a couple of words. There was a comment earlier about national partnerships. It's also worth noting that a number of the Canadian law firms have representatives in cities such as Geneva, Zurich, Paris, London, and Hong Kong. To the extent that you have a partner residing in those jurisdictions, recognize that you no longer have a Canadian partnership, and if that partnership to which you belong is going to go through any kind of merger or wind-up or roll-in of property, you no longer have a Canadian partnership for tax purposes, and you may not enjoy, that partnership may not enjoy any of the roll-in, roll-out, or merger provisions that are available to Canadian partnerships so defined. If those people have ceased to be partners in your partnership during their foreign posting, you have avoided the problem. Similarly, if you merge partnerships, if you are going to abandon, if one or both of the firms are going to abandon their old premises and move to new premises, you should take steps to ensure that the partnership that is abandoning its old leaseholds enjoys an immediate terminal loss on those leaseholds. If you do not take specific steps in merging your law firms, the two firms coming together will not enjoy a terminal loss, even if they are abandoning their old premises. So specific steps have to be taken. Lease inducement payments. Reference was made to the skyrocketing levels of rents in downtown Toronto. All of us are beginning to hear that professional firms may receive from their landlord a payment that is a tax-free capital receipt under the guise of a lease inducement payment. A lease inducement payment. These have been sanctioned both in court cases and more recently in the interpretation bulletins of Revenue Canada. I just give you one word of caution. We've come to think of these lease inducement payments as totally tax-free receipts by the professional practice. That can be grossly misleading, and I make the comment to you that if you think of a partnership that you are a member of in which you have put no money, if your partnership were to receive a lease inducement payment of, say, $100,000, if your share of it were $100,000, the partnership now has $100,000 of assets. You have no cost base in your partnership interest, and if you ever dispose of your partnership interest, you will specifically pay tax at capital gains rate because the partnership interest is pregnant with that $100,000 of tax-free receipt. So ultimately, you will recognize a capital gain if the lease inducement payment is made directly to the law firm. I would invite you to reflect as to whether it's good law and good practice that the lease inducement payment be made not to the law firm, but be made to each of the partners per se as an inducement to compel them to compel the partnership to enter into the lease. I suggest that if that's good law and good commercial practice, then the payment will be received by the partners as opposed to the partnership, tax-free. The partners in turn will put the money back into the law firm, assuming that's where it was needed, and those partners will now have full adjusted cost base in that $100,000 that's been put back into the law firm. So just reordering your affairs and you get a slightly different tax result. I would also like to give one disturbing or two disturbing words to any of you who are members of law firms that have enjoyed a lease inducement payment. You should rush back to your law firm and ask your managing partner or your managing committee how they accounted for that lease inducement payment. I submit to you that the payment could have been made to the law firm, and under generally accepted accounting principles, either the inducement payment could have been made to reduce the value of all the leaseholds on which the money was actually spent, in which case, as a partner, your capital account will be reinflated only over the 20 years in which depreciation has implicitly been reduced. On the other hand, if your managing partner directed the auditors of your firm to credit the capital account of every partner, your capital account has been inflated by the lease inducement. So either one of two possibilities: your capital account was fully inflated with a credit at the time the lease inducement was made, in which case if you walk on the law firm you perhaps enjoy your capital account, or if it was used to reduce the depreciable value of the assets for generally accepted accounting principles, your capital account will only reinflate over a future period of time. And as I say, that's relevant if you're going to be leaving a law firm, not if you're going to be staying and be the last member. Just one last comment, and perhaps I can help find the pony. My concluding remarks at page 125. Most of us as professionals know that we're entitled to contribute up to $5,500 to a registered retirement savings plan. But those of you who are members, those of you who are partners in law firms where you were once employees should recognize that under the information circular that's quoted at page 125 of the paper, Revenue Canada have indicated that it is quite proper for the law firm, assuming it has a pension plan for its employees and not exclusively for its partners, if the law firm has a pension plan for its other employees, it is quite proper for the partner, who is now a partner, to contribute not only $5,500 to his registered retirement savings plan, but he may also contribute up to $3,500 per annum as a past service funding of a pension plan in respective years when he was an employee in the law firm. It's my understanding that Revenue Canada will not look to predecessor partnerships in testing whether you've been an employee of the law firm, if the law firm is a result of many mergers. But I'd say I think if you've got a significant number of years as an employee, that's perhaps worth reviewing again with Revenue Canada. The last part of my paper deals with management service companies. And I think that I should make 2 or 3 comments in the area of management service companies. First of all, I would call your attention to the fact that until very recently, the Management Service Corporation would receive income that most people would call non-qualifying business income. And roughly speaking, that kind of income was taxed not at the low rate of 25, not at the maximum rate of 50, but used to be taxed at the hybrid rate of 33 1/3%. With the tax simplification that is coming in the area of small business, Revenue Canada and Finance are throwing away this concept of non-qualifying business income, and your management service corporations will no longer be taxed at 33, but will now be taxed under those proposals at 25%. So that's a more attractive aspect for service corporations. In turn, Revenue Canada have issued many policy statements. They're continuing their attack and their review of service corporations to ensure that they are well papered, that they're doing what they're supposed to be doing and pursuant to strong agreements. And I make just two concluding remarks. To the extent that the management service corporation of the professional is going to be owned by spouses or minors or trusts for minors, it's very important to trace the flow of funds and establish that the minor or the trust for the minor or that the spouse actually put up the money to buy the shares if you're going to avoid the attribution rules. Furthermore, there's an emerging area of case law in which Revenue Canada have not yet succeeded, but it's really a warning, and that is it reasonable for a professional to allow substantial income to be diverted to a service corporation if that service corporation is owned by a spouse who put $1 in to buy the shares? And if the professional and the law firm have gone and guaranteed all of its borrowings, is it reasonable that from inception the spouse, having put in $1, is enjoying $30,000 a year of tax-free dividends from the service corporation? Now, I would recommend that if you have one of these service corporations, I would be slow to make distributions from these corporations to spouses or trusts for minors where not a great deal of money has ever been paid for those shares. And I say two last remarks. Recognize that to the extent that your service corporation will now enjoy this lower rate of 25 percentage points, it will also expose itself to the new Part 2 tax, which says that when that corporation makes a dividend distribution, that the corporation, having enjoyed the low rate of 25 points, will have to pay a Part 2 tax when it makes a dividend distribution, and that Part 2 tax will effectively lift back up to 33 1/3%, the rate of tax borne